Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, a law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of the podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
I have a question. Am I pronouncing your fair city correctly?
Oh.
I keep saying New Orleans.
People say, actually, well, the Leans is actually like real natives, like real, but they have a slightly different. I can't even say it. So separating the E and the A is actually real serious natives do that.
Oh, good.
But they do it in a slightly different way that I can't imitate. Most of us who lives here now that I've come here, we say New Orleans.
New Orleans.
Yeah.
New Orleans
would mark you as not living here.
Because I've had people call me out on this after listening to the podcast.
Oh yeah,
So
no. So
have you ever been there, Mike?
I would say New Orleans, but people who like the people on my faculty who are like true natives, they actually separate the E and the A. But there's a different way that they do it that I can't.
New Orleans. I'm not changing, but I just know it is. Anyway, we have a couple fun subjects that aren't about how to pronounce Ann Lipton's home city. This week, we'll talk about another way ESG investments can go astray and awry and lead to lawsuits. There was an interesting one filed this week related to retirement plan beneficiaries that don't want ESG funds in their 401k menu of options, and how the employer was somehow responsible for that. But we'll dig into that.
And we'll take another look at boards of directors as a kind of profession and see what the National Association of Corporate Directors actually does.
All right, let's dig into it. Let's talk about this new case, which involves a different part of law, ERISA, retirement law, which I know I'm barely familiar with. I don't know how much you've dug into it, but you probably lately have.
A little bit. It's not my field, but it relates so much to securities law that I have to pay attention to it. So it's the Employee Retirement Income Security Act. It was passed in 1974 to protect workers who have employer-sponsored retirement plans. So the problem the statute was dealing with was employers prior to 1974, they would promise workers some kind of retirement income, usually a pension plan, and then the worker would put in like 30 years of work, and the promise would just disappear on the eve of their retirement.
Well, there were steel companies that really committed serious fraud here. Yes.
Well, ERISA was passed to try to make sure that the money would be there when the employee retires.
Right.
And these days, though, most companies don't offer pension plans. They offer these defined contribution plans where the employer creates a menu of different kinds of investments, usually mutual funds, and the worker can choose to allocate some portion of their salary to whatever funds they pick from the menu. And those investments are then available to them when they retire. But the employer has a fiduciary responsibility to oversee the funds on the menu. They have to offer a selection of suitable funds that are in the worker's best financial interests. So when you're an employer, if you're setting up a 401k plan, whose funds do you imagine you include on that menu? Basically BlackRock, Vanguard, State Street, things like that. The big index fund providers. So across the country, these funds are included in retirement plans. And that's just what American Airlines did. It set up a 401k plan for its employees. And there were a couple of different options, but in general, they could choose to allocate funds to several different BlackRock funds. And these were just ordinary index funds. They weren't ESG
like the S&P.
Yes, exactly. We don't know exactly what funds they were. Basic vanilla index funds.
Could an international fund and so forth. You've seen it. You have funds like this. I've seen them.
Yeah.
So and American Airlines chose to contract with BlackRock in this case, among others, to make these funds available. Okay.
Exactly. Okay. So there was a case. A pilot brought a class action on behalf of around 100,000 participants in this ERISA plan, alleging that American Airlines violated its fiduciary obligations by including these BlackRock funds in the plan. And the reason was because BlackRock and Larry Fink, the head of BlackRock, had announced that as part of their stewardship, they would urge portfolio companies to prepare for the costs associated with a changing climate. So the phrase ESG gets thrown around. It gets thrown around in the reporting on this case. The phrase ESG is all over the actual opinion, but that's kind of a distraction. It wasn't about ESG in some general sense. This was about climate change. And
a specific subset of E.
Yeah, exactly. It was about BlackRock's climate change stuff. And the pilot argued that BlackRock's climate activism was intended to advance a social goal and wasn't really about maximizing the wealth of the funds, and that it sacrificed returns in some way.
Oh, interesting.
Yeah.
Okay.
So American Airlines, according to the pilot, violated its fiduciary duties to plan participants because it didn't take any action to discipline BlackRock. And this pilot, he filed this case in the Northern District of Texas, where he was actually sure to get this famously aggressive conservative judge, Reed O'Connor.
A little bit of judge shopping going on.
There was just absolutely judge shopping. And, I mean, this judge had previously struck down the Affordable Care Act. He rejects gun regulation. He's really sort of famous for this. And after a bench trial, Judge O'Connor just, like last week, or very recently, agreed that American Airlines had violated its fiduciary obligations to the ERISA plan participants.
By including
including the BlackRock funds, or by not disciplining BlackRock, trying to get BlackRock to stop the
But it wasn't a specific
climate.
fund. That was something I read this casually.
No.
That was something I kind of thought, is that the pilots were objecting to one or another ESG-oriented fund.
No, these were
exactly
the options. Exactly. These were just index funds. All of them were just normal index funds. It was the fact that they were BlackRock funds, and BlackRock was doing climate activism.
And BlackRock expresses its activism in two or three different ways. Larry Fink, he hasn't done it yet this year, but he usually writes his letter.
He's backed off after all of this.
He's slowed down.
Yeah.
But customarily he writes a letter to all the CEOs of portfolio companies, and past letters used to say stuff about how we got to be careful custodians of the environment, and then they also vote in various ways, and they have very extensive stewardship policies about how they are not going to deal with environmental issues and climate change. They aren't really much of their own activist.
Right.
They've never sponsored
No. Mutual funds never do. Mutual funds never do.
Right.
But BlackRock and others sometimes would vote in favor of these climate change resolutions. So So this was the evidence that was put forward to show that they were pursuing a social agenda and not maximizing the wealth of the funds.
Right. And so this is a very broad indictment.
Yeah.
I'm using that term loosely because of how American Airlines kind of policed the choice of funds in their 401k.
And quite frankly, how every employer does, because BlackRock is ubiquitous. It's in every fund. So I mean, there's so much going on here. I don't really know where to begin. So I mean, let's talk about how business law ordinarily works.
Okay.
Suppose you have an operating company, not a mutual fund, just a normal company. And the directors of that company decide they're going to reduce their carbon emissions, they're going to start making products that can be powered by wind or something like that.
Sure.
If a shareholder brings a lawsuit saying you are sacrificing profits to advance a social goal, that claim is going to be thrown out of court. Why?
Oh, absolutely, because the business judgment rule.
It's the business judgment rule. In other words, courts defer to the business decisions of corporate directors. They're the ones who get to set corporate strategy. And it's plausible that this is wealth maximizing. Maybe you think there are going to be new emissions regulations. Maybe you think consumers prefer greener products, or that wind power is going to get cheaper. If you're right, then these adjustments to your product mix are absolutely wealth maximizing. And normally a court, like a Delaware court, would defer to that choice and reject any challenge by a shareholder. But there's a caveat, and that's you, Mike, you personally. If the directors adopt a bad strategy that actually is reducing shareholder returns for climate change purposes, it's costing the company money and it has no financial justification. Mike, what are you personally going to do?
I'm going to go after the guy.
You're going to go after them. You're going to do activism. And you can do that because these companies are responsive to public markets. And so that's why courts have the business judgment rule, because they say, forget it, I can dismiss the shareholder challenge because I know the markets are going to take care of this kind of thing.
The market for corporate control, as we call it.
Exactly. That's what's going to take care of this. So courts don't have to get involved. But let's say we're not talking about an operating company. We're talking about the strategic choices of a mutual fund. It's not clear the same market operates in the same way. There's no activism in an open-end mutual fund. Shareholders are retail. They're unsophisticated. They're locked in through their employer's retirement plan. It's just not as obvious that the market mechanisms work that way. That's why we have ERISA. So I can actually see a case that would say something like, for a court to say, I'm not just going to defer to ERISA trustees or mutual fund advisors, and when they say they're adopting a wealth maximizing strategy, I'm actually going to look a little harder to make sure that's true.
I'm going to look at the evidence and look at the evidence against the
part,
law.
Right, that part I can kind of see, and that's what Judge O'Connor did here. He actually explicitly said, I'm not just going to defer because you played lip service. I'm going to seriously look and make sure that you really articulate a strategy. Okay, fine. You're going to look closely at the strategy. But after saying that, he doesn't actually look. He doesn't actually look at any of the evidence.
No, nothing in the record of his. Okay.
He immediately pronounces that if shareholders are concerned about climate change, they must be pursuing a social agenda. And the opinion, when it came down, literally Los Angeles was on fire. Estimates were something like $150 billion in damages. But if any shareholders,
250.
Oh, really? Is that where it was?
Yeah,
The last headline said it was 150. If any shareholders concerned about this, they must not be interested in long-term wealth maximization.
Right.
His only evidence, if you could even call it that, for the idea that focusing on climate change sacrifices shareholder wealth is he has the statistic that in 2023 ESG funds underperformed indexes. He doesn't cite the study, by the way. I have no idea what this study was.
Oh, there's not even footnoted?
There's not even footnoted. I don't know what the study was, but even if you say it's a legitimate study and that 1 year ESG funds underperformed indexes, these were not ESG funds. ESG funds are ones where you select companies based on criteria. These were index funds. He also spent some time on the proxy contest at Exxon from a few years ago.
Really?
And he
I didn't read the decision. I didn't. Now I have to go look up the decision. Okay.
Yeah. So it's 70 pages, but it's double spaced, so it's easy to read. But he spent some time. He spent some time on
what size font? Is it bigger letters?
So it's always like 12 or 14 because judges are old and they can't read. But he spent some time on the proxy contest at Exxon from a few years ago, where BlackRock, along with institutions like Vanguard, voted out 3 sitting Exxon directors in favor of these dissidents who ran on a campaign of forcing the company.
Number one, I know the guys who did that.
Right. They went on this climate change campaign. And Judge O'Connor just declares out of nowhere that there's no rational economic sense for that vote. That's the phrase he uses. No rational economic sense.
That's a cite. Okay.
Yeah, he actually says that. But what he doesn't do is actually look at the campaign in that case, because if he had, he'd have noted that the entire campaign was economic. The argument that was made by the dissidents was Exxon underperformed the market because it was not making necessary adjustments to the business risks associated with climate change, and like a lesser demand for oil and gas. And I just have to point out, by the way, that Steve Bainbridge, I'm sure you know the name, he's a professor at UCLA. He's a professor and he's a huge shareholder wealth maximization. He is the most hardened shareholder wealth maximization person that you can believe.
And board primacy.
Yes, all of that.
Yes.
And he wrote in his book about shareholder wealth maximization that the only reason this campaign at Exxon succeeded was because the dissidents made a financial case.
Made an economic argument.
Exactly.
Right.
So Judge O'Connor highlights that BlackRock sent letters to 120 companies, the letters you're talking about, asking them to report on climate change in line with the recommendations of the Financial Stability Board's task force on climate change-related financial disclosure. It's a framework, the TCFD framework, the Task Force of Climate-Related Financial Disclosures, and BlackRock urged that companies adopt it. But that is a financial framework. It's a framework for pricing climate change. And just one other point on this, because this is driving me crazy.
Go ahead,
he accused American Airlines of being in league with this social responsibility mission because one member of the board that was overseeing the plan emailed around this article, a New York Times article, about making 401k plans more socially responsible. But that article explicitly said you could make 401k plans more socially responsible without any financial sacrifices.
Without compromising without performance. Yes.
Exactly. Judge O'Connor quotes the headline of the article multiple times, which is how to make your 401k a little less evil. But he never actually quotes the part of the article that says
either he did read the article
or didn't care.
Right.
Yeah. So that's I can sort of understand the train of thought that leads us to looking more closely than you would at an operating company at to what you're doing, but he doesn't actually look.
Right. So there's a procedurally the way he went about this clearly had evidently had an agenda.
Yeah.
And he was using this case to kind of push it. So what? Let's talk a little more about the American Airlines end of this. So they're the defendant here.
Yeah, they're the defendant.
Not BlackRock.
Not BlackRock.
Right. So if American Airlines, I mean, do they have a choice here? Can they
Yeah.
I mean, what if BlackRock is like somehow harming shareholders and causing American Airlines to breach its fiduciary duty to 401k beneficiaries? Why would they do that, and what could happen, and what's possible here?
Yeah, so you'd think, so he has to have a story for why American Airlines wasn't taking action to, stamp out this climate activism, if that's what it was. And he says that American Airlines was motivated to overlook BlackRock's activisms for a couple of different reasons. Partly because BlackRock is a large shareholder of American Airlines and a debt holder of American Airlines. So it has market power. So he thinks that American Airlines is sort of enthralled to BlackRock.
Or beholden in some way. Right.
And which, again, I point out, every company is. If that's true of American Airlines, it's true of everybody. Right. But the other reason that he thinks that American Airlines allowed this was because American Airlines had its own non-financial sustainability goals, and it thought that BlackRock was sort of pursuing the same goals that American Airlines had.
So there's some commonality of interest here.
Exactly. But he nowhere, not once, not ever, makes any attempt to show that American Airlines, that company, had any non-financial goals. American Airlines talks about climate sustainability, but again, he immediately leaps to the conclusion that American Airlines also was not pursuing shareholder interests, was not, trying to wealth maximize, but had its own non-financial sustainability agenda with no evidence at all, other than the fact that American Airlines expressed concern about climate. So I have to, every business law, every introductory business law student, the business law case, introductory business law class, every single one of them, every business law student reads this one case. It's called Dodge versus Ford.
Sure.
You've heard,
something about it. There was
yeah.
Pro Market just had an article about it this week.
So it's this really famous business law case from 1919, decided by the Supreme Court of Michigan. It's about Henry Ford. He stops paying a special dividend to his shareholders so he can use the money to expand his factories. And the shareholders, the Dodge brothers, the founders of, they ultimately, they found the competitor. Right. The shareholders sue because they want the money to set up their competing business. They sue, and they claim that Ford is stopping this dividend to pursue a social agenda. And they base their claims on Ford's own testimony. Ford says he wants to expand his factories and make cheaper cars because he wants to benefit society and raise up the condition of the working classes. He actually gets on the stand. He gets on the stand and he testifies it's wrong for businesses to make too much profit because they should give back to their communities. The actual quote is, "We don't seem to be able to keep profits down." From this testimony, the shareholders are arguing you are pursuing a social agenda. That's why, and you're running the company badly. And they win. The court holds that Ford is violating.
So exactly. They awarded in favor of Dodge. Okay.
Exactly. The court holds that Ford is violating his fiduciary duties to the Dodge brothers and orders that he pays this dividend. And the case, I got to tell you, it's a historical laughingstock. At the time, the company was in a fierce unionization battle. Ford was trying to break the unions. Of course he said he was running the company to benefit employees.
Right, of course.
What else would he say? Why on earth would you believe him? That's how this opinion reads. If Larry Fink and American Airlines talk about the planet and sustainability and only incidentally about numbers, that must be the God's honest truth. There's no such thing as public relations in this world.
Right. Oh, man. So this case was just decided last week or two. Mm-hmm. So presumably and this is at the federal district level.
It's a federal district level. So assuming it doesn't settle, and that's always on the table, we have some things that Judge O'Connor left open. He didn't decide yet whether there's any calculable financial damage. There are going to be further hearings on that. So we don't know if he's going to award damages or if he's just going to order an injunction. And once that's decided, American Airlines can appeal, but it goes to the Fifth Circuit, which is the same court that struck down the NASDAQ diversity rule. So I don't know where that's going to go.
So the appeals court that's going to hear would hear this might be favorably disposed to agreeing with this.
Yeah, exactly. But even leaving aside the ESG thing, one of the big themes in this opinion is that BlackRock, along with a few other asset managers like Vanguard, like State Street, dominate the public markets. They hold large stakes in every company. They administer the 401k plans.
20% or something.
They set the standard of care for how the plan should be administered. And that's a situation that's rife with conflict. And to be honest, this is all throughout his opinion, that American Airlines is conflicted because of its ongoing relationship with BlackRock. And to be honest, on that front, I can't even say he's wrong. It's just that BlackRock, much more than other players, draws a lot of conservative ire, and that's because because Larry Fink talked about climate change. So I'm actually sympathetic to the big, it's all one company problem, but not the climate change thing. But
no, that's an issue that activists have
yeah.
for a long time objected to, that like Fidelity and Vanguard were always in cahoots because the companies, those funds wanted to manage
exactly.
pension
They
money.
want to mention it, exactly. That's been written up, and so that's an ongoing concern. And now it's not even that that BlackRock wants to cater to American Airlines so it can manage its funds. It's actually he's concerned the other way. American Airlines wants to cater to BlackRock because BlackRock is such a big shareholder. And I can't say that that's illogical. I think that's a thing to think about, but I don't think, but not in this context.
No,
but
this was a little too far apart from that.
I will say, though, there is this also another theme where business decisions these days are being targeted politically as violations of managers' fiduciary duties to shareholders. So not long ago, conservatives organized a boycott of Target because it carried this LGBTQ merchandise.
LGBTQ plus stuff, yeah.
Its stock price dropped, and then a shareholder sued, saying that Target's board failed to oversee the risks of its ESG activism.
Right.
And a Florida court sustained that complaint. That case is going forward as a federal securities board complaint. That's going ahead. Well, they're in mediation now. And because a court seemed to think that it was so obvious that carrying gay-themed merchandise would result in shareholder boycotts. It was so obvious that it's plausible to allege that the corporate managers weren't pursuing shareholder interests, they were pursuing their own agenda. So we've talked a few times now about whether companies will consider leaving Delaware and incorporating in other jurisdictions. And I think these cases highlight why that would be risky. Because, these are federal cases. The BlackRock case is a federal case. The Target case, that's a federal securities fraud. But imagine you're a company incorporating in Texas. If you make a decision to attract a liberal customer base, like you make a movie with a trans character, are you at risk of being sued? You could be sued for violation of your fiduciary duties. We know what a Delaware court would say. The Delaware court's going to say that's business judgment, go away. But are you sure that a Texas court is going to say that?
Oh, wow.
A Delaware court did say that. A shareholder challenged Disney's opposition to DeSantis's Don't Say Gay law, and Delaware tossed it. Are you sure that a Texas court would toss it?
I don't know.
Exactly.
Here's the thing: is we don't know. There's some evidence that Texas jurisprudence might kind of favor a little bit.
We don't know.
This business court is so new in Texas.
It's so new and so politically, and right now this has become such a politically hot potato that I don't know that these judges who have 2-year terms and appointed by Greg Abbott whether they're going to turn out to be conservative social justice warriors as well. And no company knows. So I think that's why Delaware's still in the running here, like despite all the chatter about leaving. But I will say one other thing, and then we can move on. But the judge found.
Go ahead.
The judge found that American Airlines didn't even oversee BlackRock's voting behavior, and that it was industry standard to essentially ignore how funds were being voted. They invest in the funds, they choose the funds, but they don't really look at the voting behavior. And he said that's standard. Well, why is that? According to the judge, it's because of all these conflicts. But I actually think the likely explanation is the voting behavior doesn't matter. These are climate change resolutions. They're not binding. They're precatory. They're just suggestions, and they're vague. They have to be under SEC rules, because if they're too specific, the SEC will say they're interfering with management prerogatives. So in a broad sense, I think that Reed O'Connor is actually right. BlackRock really was pursuing its own agenda. But it wasn't an agenda to save the world from climate change. It's a public relations agenda. It wins brownie points with the public for appearing to care about climate change. Maybe BlackRock avoids tighter regulation. Maybe BlackRock helps companies burnish their own sustainability, images. Yeah, exactly. If they adopt these long-term sustainability plans that don't actually do anything. So there is a real argument that BlackRock is using pension fund assets for its own purposes. But Reed O'Connor got the purposes wrong. It's not necessarily to change the world. It's to make BlackRock look like a hero.
Because BlackRock, and BlackRock has in fact changed. They evolved a little bit, and they're a little less interested.
Because it doesn't benefit BlackRock much anymore.
This case probably related to decisions that American Airlines made in 2020, 21, 22.
2022, exactly. Exactly. But I think that there's a reason why it all begins with American Airlines not even overseeing BlackRock's voting behavior, and because other than a few situations like activists and merger, the voting behavior may not really matter that much at the end. Reed O'Connor is making it sound like it matters a lot more than it does.
Yes, I agree. So All right, we should take a break. This is taking a lot of so let's do that, and return in a minute to talk about the National Association of Corporate Directors and what they do here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. And Mike, we are going to talk about the National Association of Corporate Directors, NACD. So what is NACD? What do they do?
Well, NACD is an association. It's supposedly a professional association that ties together people who serve on boards of directors in North America, but really in the United States. And it's a fairly substantial group. It's got like 24,000 individual members. Mm-hmm. They're represented like almost 1,800 U.S. boards of directors. It's kind of a Washington type based organization. It's got a staff of dozens of people. Mm-hmm. Memberships are not cheap. To join,
if you're just
an individual one, you pay $1,500 a year roughly. Mm-hmm. If you want your board, there's about $10,000 a year for a board. So this is a fairly well-run and well-endowed kind of organization. It's got chapters all over the U.S. It's like 20. There's a Chicago chapter. I've been to their meetings occasionally, and they do a lot. And there's a national meeting that they have once a year. They do all sorts of research, and they offer education and certification programs. They do surveys. They actually have a little consulting unit. They make some additional fees that way. That they provide basically board education, and they advise boards about maybe succession and so forth. They have prizes at the annual meeting. They hand out the most distinguished award in corporate governance or something like that. So it's like one of these organizations that kind of ties directors together and presumes to kind of educate them. And
so educates them on how to be a good board, or
how to be a good director. Mm-hmm. Okay, and that just sort of stating it that way is a little odd. Okay, because if there's sort of three types of people on boards of directors. There's insiders, the CEO,
right?
And they're doing it because they're kind of the company representative. We can talk about whether that makes sense or not, but that's for a different day. Then there's shareholders, investors can serve on boards. Portfolio managers and so forth. So for example. We're watching right now a proxy contest with Air Products with a hedge fund called Mantle Ridge, and Paul Halal is the CEO of Mantle Ridge. He is a candidate for the board of directors there, so he'll serve on it. He doesn't really care about the NACD, I don't think. Yeah. Okay, because he's representing his fund. Right, but nonetheless, there are most of the 24,000 members are these independent directors. Mm-hmm. They're, retired corporate executives, former government public servants, academics, all these people that kind of want to be on boards of directors. And if you're one of those types, you probably have joined the NACD through your board. You've paid the fee yourself. So it's and that's the majority. Well over 90 or 95% of directors are these independent directors. So the NACD, I would guess, kind of speaks for the those directors and kind of represents their views. And it was those views that I was kind of curious about.
Okay, so, what are those views?
Something happened that I was got interested in. At some point, you recall we were talking about Glass Lewis at some point, and as it turns out, Glass Lewis is active in the NACD. They're a sponsor of some of their work. We'll talk about their sponsorships and so forth a little bit. And I wondered why would Glass Lewis be interested in the NACD? And as it turns out, as we've talked about before, Glass Lewis serves companies. They have this little consulting business. And so they are interested in cultivating directors. And so I started looking into the NACD and wondering, wonder what they kind of do for directors kind of specifically, and how much of their work focuses on representing investor interests. And that's where I found some interesting stuff.
Okay.
And you know, I started looking at some of the research they do and so forth. In particular, there was one big research project that they did about a year or so ago. That was this. They have these blue ribbon commissions, and this one was on dynamics and culture within the boardroom. And they convened this whole commission. They had a bunch of meetings, issued a big report. And so I looked into kind of what that commission involved and so forth, and how much. I was wondering, okay, if they're going to focus on culture within the boardroom, how much of their findings related to really representing investor interests diligently, and how did they kind of incorporate investor views into what the boardroom should look like. And so that commission had like 24 representatives. There was the head was the retired CEO of United Airlines. There was another CFO that was a retired corporate CFO that was there. There were 16 corporate directors, a board consultant, a comp consultant, a benefits consultant, an attorney, a professor, and then also the NACD president. Notably, there were no investors, no one, no shareholders, no fund managers, nobody among these governance leaders.
Okay.
And I found that kind of curious. And I kind of wondered, I wonder what else the NACD does that sort of has this, is missing this investor perspective. And you could read the report and so forth, and there's a lot about how boards need to get along and how the culture needs to be very well refined and so forth. There was a little advice in that Blue Ribbon Commission's report about how we're going to deal with problematic directors. I can guess what they mean by that. I've been one of those.
But you mean directors who make a fuss and say
directors who try to kind of not necessarily go along with the crowd. But there was nothing in there about how board culture should cultivate and promote a healthy relationship with shareholders. So I started digging even further into there, and I started wondering, okay, kind of generally, what at the NACD revolves around representing investors, and I would describe it as blessed little. There's a lot of resources there. I counted like 1,900 different resources in a little search engine on their website. There's handbooks and more reports and analyses and articles and FAQs and all sorts of stuff. And a lot of things there that presumably a director would need. So if you're new to this, maybe you go to the NACD, join the organization, and start to learn. Okay, how do I represent shareholders? And there's like nothing there, nothing specific in any of these resources that says, here's how to represent shareholder interests. And I found that weird. There was, guides for how to talk to investors a little bit. There was a couple of surveys. But out of 1,900 resources, there was, a small handful that had anything to do with representing investor interests. And that's kind of generally. I then thought a little bit about, okay, what about the NACD guidance or resources has to do with activists? And there is some really good content there about how directors need to think about activists. And so some of them are like preparing the board for shareholder activism. Are you prepared for a shareholder activist campaign? A good one was, who's afraid of the big bad wolf? Okay, there was, and then I mentioned there's these chapters. The chapters have, frequent kind of meetings and discussions about activist investors. Okay, but all the content seemed to revolve around how to make life hard activist investors.
They weren't about how can we accommodate concerns, how can we
or
assure,
how can we listen carefully, or how what
Yeah.
are activists about? Okay, I looked at some of the agendas for some of these chapter meetings, and there's some stuff about activism, but it was all about how to make, again, as I said, how to make life hard for
Yeah,
activists. There was
how to
nothing
fend
in
them
there
off, not about how to consider whether they have a point.
Right, exactly, and maybe there's something valuable they're bringing to this. So that seemed to be kind of the thrust of this, and I found that more than merely interesting. I found it kind of troubling. Okay, and none of this is surprising because the NACD is not really an advocacy organization. There's no kind of policy that they're trying to push. They don't really lobby for much in Washington or in front of the SEC. I think they've given occasional congressional testimony about things, but it's mostly this kind of educational organization. And then if you look, what kind of education, there's there's 48 different kind of partners that are listed on their website who provide significant support to the NACD. They're sponsors of chapter meetings. They, I'm sure, write a big check each year to the organization. It's all sorts of law firms and headhunters and consultants and all sorts of people who all they want to do is get into the board of directors. Their interest is in trying to get board access. None of these folks are really trying to promote healthy relationship with shareholders. They're trying to advise these
They're trying
independent
to
directors
Yeah.
in their capacity as board members.
I see.
So this is a platform for these folks to kind of push an agenda, which tends to make activists kind of look bad. So it strikes me after looking at this that the NACD is really mostly helping boards to kind of manage themselves and to kind of help promote executives to more and better board directorships, and that's not unimportant, but if I'm a shareholder, I'm really electing these directors to represent my interest, and there's almost nothing there that promotes that kind of education about how to interact better with shareholders, and that gets troubling. That's what bothers me.
You should contact whoever one contacts and,
I know,
and point this out.
Put it this way: after this, and I wrote something about this. After this, I'm not expecting any invitations to speak at NACD chapter meetings about activism, but that's okay. But the larger point here is that I've long kind of thought about and protested that there's this kind of odd, peculiar, dysfunctional structure that draws directors much closer to executives, this kind of professionalization of independent directorship.
So this is why you were the so-called profession at the top of this, yeah.
Exactly. Links them much more closely to the executives that they're presumably hiring and overseeing and paying and supervising and maybe firing, and pulls them away from representing shareholders. And the NACD is kind of emblematic of that. It's sort of creating this enormous organization and culture that separates directors from the shareholders that they represent, and that is a problem. The NACD is in fact reinforcing these dysfunctions rather than trying to educate directors about how to represent shareholder interests better. Right.
Yeah, especially if they're giving advice for managing difficult directors, and I mean difficult could be anything from asleep at the wheel to actually trying to induce positive change.
Exactly, right. So I mean, I've long thought that, the kind of education that the NACD purports to provide, we could do in an hour or two. I could educate directors about fiduciary duties of care and loyalty, and a little bit about how to get along with each other. That should take an afternoon. That does not take an entire organization and this whole professional staff and so forth to get these folks up to speed. What we really could use is some solid education about how do portfolio managers kind of think. What do they look for in company performance? What are some of the current issues that investors are thinking about? That would be a really valuable contribution, not necessarily, I guess this stuff. So anyway, so that was my adventure, my wandering around the world of the NACD, and
right.
it was pretty interesting. So I think we've had enough here between
Okay.
between this kind of dive and then talking about the American Airlines and their 401k
Sure.
plans. So I think we can move along. Shall we?
Right. Okay.
All right, let's wrap up. Thanks, Ann. It's terrific talking again. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed, as always, by Free Float Media. Thanks for listening, and we'll talk again soon.